Gentlemen, welcome to the Newburyport Zoning Board of Appeals for hearing Tuesday, August 12th, 2025. It being the appointed hour of 7 p.m. We are going to open our hearing and get things underway. My name is Rob Champetti. I have the privilege of serving as the chair of the ZBA. To my immediate left is Mr. Ken Swanton, our vice chair. To his left, Mr. Stephen Weil, secretary. To his left, Mr. Gregory Bennett, member. Mr. Walter Channon, member. Mr. Larry Ginta, associate member, and Mr. Jared Eigerman, member. Associate member. To my right is Mr. Andy Port, our planning director, and Ms. Caitlin Sullivan, our city planner. And joining us online is our esteemed keeper of the minutes, Gretchen Joy, who has the unenviable task of having to type every single thing all of us say. So we will have her in our hearts. But Gretchen, can you hear us? You want to make sure?
I can. I'm here.
You're the straw that stirs the drink in these things, so we appreciate you making sure you can hear everything that we're doing. Ladies and gentlemen, what I'd like to do when we open, we're going to open up our hearing. I'll do a roll call. We'll establish that, as it would suggest to appear, that we have a quorum of voting members. I will indicate for the record which of the voting members are the 5 voting members for this evening. And then what we like to do is just simply get right into the public hearings in sequence. There's a few of them that are requesting special attention or continuances. We do them in sequence unless there's a reason not to. I see many familiar faces in the room, so I will try to do the abridged version of what I typically offer when we open up these hearings, which is essentially a lay of the land on how these meetings take place. I'll just do a quick overview just so that you know what to expect for purposes of workflow and cadence and how our business gets done here at the ZBA. We do, for the moment, continue to broadcast simultaneously through this device in front of me called the OWL, which is recording and also streaming live video to our Zoom feed. We will be undertaking a change with respect to that, going with a in-person, fully in-person, less extenuating circumstances relating to a board member protocol, and that is just to try to guard ourselves in terms of efficiency. It's difficult to run these simultaneous platforms and be efficient and fair with everyone. So we are taking a great deal of time and courtesy to give folks plenty of advance notice on how that will take place and when it will take place. But for now, we're doing it hybrid. So without further ado, I'll call the roll and we will get things started. Calling the roll of the Newburyport Zoning Board of Appeals. Mr. Stephen Delisle. Here. Mr. Ken Swanton. Here. Mr. Walter Chen. Here. Mr. Gregory Bennett. Here. Mr. Larry Ginta. And Mr. Jared Eigerman. Here. And I'm present as well. That is 7 members present. That is a quorum. Our 5 voting members this evening will be myself, Mr. Swanton, Mr. Delisle, Mr. Bennett, and Mr. Channon. Our alternates, Mr. Ginta and Mr. Eigerman, will step into voting to the extent there is any kind of conflict or recusal. Any alternate member that is not voting is still participating fully in deliberations, in questions. The only thing that member doesn't do for purposes of that particular application hearing is vote. But in every other respect, they function much like an alternate juror. So there is one matter that will have a separate voting membership, and that is the application of 9 Bromfield Street. 9 Bromfield Street was opened during a hearing when I was absent. I was not able to qualify myself by listening to the transcript due to travel and some other family commitments, but that means that the voting members for that application would be Mr. Swanton, Mr. Delisle, Mr. Channon, Mr. Bennett, and Mr. Eigerman. So those will be the 5 voting members. Both Mr. Ginta and myself will remain in the room, but simply not voting. I won't be participating because I wasn't here for the any part of the voting over here. Okay, so having taken care of our housekeeping business, essentially what we do, and I'll give you the quick snapshot, we will go through legal application by description in the order in which it's on our agenda. All of that material is online as well. So anyone that is following on Zoom, all of this material is going to be simultaneously broadcast on the screen behind me. All of the members have it on their laptops as well. So fear not if you see us not turning around, we're looking at it right here. Anything that's being referenced by an applicant or an applicant representative is going to be brought up. Ms. Sullivan will bring that screen or that slide up so that everyone, both in the room as well as at home, can follow along and see what's being referenced. What we do first is I will call the application in order by the applicant's name, the address, as well as the relief being sought. For instance, if the applicant seeking a variance, I'll say the applicant seeks all necessary permissions, permits, and approvals for a variance or a special permit or special permit for nonconformity. So you needn't, God forbid, have to be an attorney to understand what's happening with respect to any particular application and what's being sought. We then just add the kind of natural language descriptor, the applicant seeking approval to demolish a portion of their screen porch and add X, Y, Z. So that it's easily digestible at a glance. You don't even have the agenda in front of you. You'll understand what the applicant is seeking relief from the board for. After I describe and open the hearing, it's essentially the legal notice that was sent around. We then turn it over to the applicant to present, the applicant representative or the applicant themselves, or their architect, professionals, or otherwise, all of the above. We'll ask that we take the podium just because we're still broadcasting simultaneously. We rely on the microphones and the projection. So if we ask that you present the application, then after the applicant presents, once that's complete, we'll close that portion of the public hearing and go into public comment. Public comment is when any member of the audience or online can speak their mind either for, against, or somewhere in between, or nowhere in between, just want to be heard. We ask that you kindly govern yourselves accordingly with respect to the courtesy of our request and keep it around 2 minutes or so. We do that, though not so much in this room, but in larger rooms, it's important so that we can move efficiently and everyone has a bit of a say. After we go through public comment, we'll do it in the room first, then online. Once we close in the room and online public comments, we will close and and go into the section called questions from the board. Please know that if you make a public comment and it's in the form of a question, don't worry if you do not hear us respond to your question directly. We mean no discourtesy or disrespect in that it is simply sort of our adherence to the format and the Robert's Rules of Order that we will hear your question. If you frame it in the form of a question, we'll hear your comment and we will absorb it. And surely you will hear some form of your question either restated verbatim or adapted in some way from one of the members of the board in that third section called questions from the board. That's when you will surely hear everything that was raised. But we just want to alert folks that you won't be getting an answer from us, but that is not any intentional disrespect. So after we do questions from the board, we will close that portion of the public hearing and go into deliberations. That's the final portion before we vote, where we deliberate the legal criteria by which we must evaluate the application. We will describe what the standard is, what findings we must find, and then you'll hear the members of the board out loud right here in this room discuss whether we feel the applicant satisfied that burden, whether there's some questions, whether they fell short, whether there's some issues. It's easy to see which way the board is sort of evolving and bending as it evolves along the way. Once we get through deliberations, we will then close, at which point I will ask a member for a motion. It's always in the form of a motion to approve. And that's simply the format the means by which we place the motion on the floor for vote is in the affirmative. We ask that a member make a motion to approve. That doesn't mean that the member plans to support the application. It doesn't mean that the moving member plans to vote yes. It's just the format, framed in a motion to approve. That motion needs to be made and seconded. Once it's made and seconded, I call the roll. And in order for the application to be successful, at least 4 members must vote yes. And if 4 members vote yes, the motion carries and the application is approved. That's essentially the lay of the land. So without further ado, we will get into our first application. This is the continuation of the application of Charles Griffin, 10.5 Auburn Street. This was continued from July 8th, 2025. The applicant seeks a variance to allow a short-term rental unit on a parcel adjacent to the owner's primary residence. I understand Attorney Roloff is here on behalf of the applicant. Attorney Roloff.
Mr. Chair.
Yes.
I'm disqualified because you started before I was on the board, so I can't get it all.
Very good.
Legally. I'm also.
Okay.
Thank you. Jeff Roloff, attorney for Chuck Griffin, office at 44 Betterman Street, Newburyport. we're actually requesting a continuance tonight. We really hope to bring this process to a conclusion tonight. Because of all the voting members being here, let me just point out that we have submitted supplemental materials since the last discussion that the ZBA had. A package from me dated July 3rd, addressing issues that were discussed in the previous two meetings. I was not involved in those meetings, so I did want to chime in on some of the issues that were discussed during those meetings. So that July 3rd package is in your materials. We also submitted a copy of the preservation restriction, a lengthy document that is currently pending with the Mass Historic Commission. It was approved by the Newburyport Historic Commission in January. So we've been hoping to conclude that process. Yesterday, Patricia Pecknick filed what she called an emergency enforcement request with the city, looking to enforce the zoning board's 2019 variance decisions. And you may recall, I think some of you were on the board at that time. Chuck had sought variances from the board, and in support of that request, submitted a draft preservation restriction. That was, the variances were granted. A few months later, Chuck received an approval from the Newburyport Historic Commission for a revised version of that PR. That was sent to Mass Historic Commission. They, a few months later, sent it back. They had comments. It wasn't the same form as some of the other Newburyport restrictions. And that led to a process of basically restructuring and revising the preservation restriction. The enforcement request raises the issue of whether or not the preservation restriction has been revised so much that it's now inconsistent with this board's 2019 variance decisions. I don't think those are directly relevant to the application in front of you, but I do think it's reasonable, and we would like to address those enforcement issues before we ask the board to vote on the pending application. We don't want there to be a time urgency situation with respect to those issues. How we resolve those issues, not totally clear right now. We just heard from Mass Historic Commission that they're at the end of their review, so we're going to be getting comments from them soon. We will be working with staff. We may come back to the ZBA with a request to basically chime in on the issue and potentially issue an amended set of variances to reference the new preservation restriction. So that process not yet determined, but we want time to sort that out. I'm hoping to have discussions with Ms. Pecknick and whoever else is involved in the enforcement issues. So we'd like some time to work those out. So that's the basis for the continuance request tonight. And I wasn't planning on getting into the substance of this true application tonight because of that. And the request is to continue it to 2 months out to October.
Thank you, Attorney Roloff. Yes.
What date did you say, October?
I'm sorry, October 14. I think that's the first meeting scheduled for October.
Reason I raised the issue is that's the only meeting I know I'm gonna miss.
Okay,
And then you'll be down.
yeah, we don't want to,
Just,
that's fine. No, I appreciate the heads up on that. Let's kick it to October 28. That was ambitious anyways, because it's gonna take a little time to work out these PR issues. We know that. So whatever date after October 14th, you are anticipating a quorum, that's the date we request the continuance. So I know you don't know for sure.
Pre-Halloween plans. I think we're pretty, it's far enough out. That's fine. That's the.
October 28th makes more sense.
You know, Mr. Swanton's absence will be a challenge for the absence.
Yep.
So, okay, members of the, was there anything else?
No, I mean, because all voting members are here, if there are questions related to any of this, I'm happy to answer them, but otherwise, for me, no.
Having heard the request and the rationale from Attorney Roloff, on behalf of the applicant, do we have any comments from the board? If not, do we have a motion to approve the request or continuance?
I'll move.
Very good. Second. Mr. Bennett, motion is made by Mr. Swanton, seconded by Mr. Bennett, calling the roll. Mr. Swanton. Yes. Mr. Bennett.
Yes.
Mr. Shannon. Yes. Mr. Ginta. Yeah. And I vote yes. It's 5 in the affirmative. The ayes have the motion carries. We'll see you on the 28th.
Thank you.
Thank you. Okay, moving on to our next application. This is Lydia Southwest, and forgive me, did I pronounce that close?
Pretty close.
Pretty close? How may I pronounce it?
Oh, Lydia Szydłowska, it's just a Polish complicated
No, no,
name
no,
with
no.
11 letters.
Thank you. Appreciate it. I appreciate that. I just wanted to, I won't be able to do that, but I wanted
It's
to at
okay.
least try.
Okay.
Thank you very much. This is the application continuance from 7/8/2025, and this is the application for 9 Bromfield Street. I was absent, so I will be stepping out and deferring to Mr. Swanton, our vice chair, and to continue.
My name is Lydia Szydłowska from Pioneer Design and Construction, representing here our client, Ryan Johnson, the applicant and the owner of Route 9 Broomfield Street, I believe it is. Today I would like to summarize a little bit on what we're asking for. We're basically asking for expansion of the non-conforming structure into the 3rd floor. Currently, there is a 3rd floor already in the building. With the roof starting at the 3rd floor level, as you can see on the section, which is located on page A3.0. We are going up from the existing top of the plate, which is about 4 inches off the floor. We're going up about 3 feet up to the main roof line, and then setting it up at 8'4.5" at the flatter roof portion. What we had changed since is that to minimize the height of the dormer looking structure, it's not a dormer, we had enlarged the pitch by 1/2 inch, bringing it from 4 to 4.5 to make sure that the wall is sitting a little bit lower. We slightly reduced the small windows that are shown on page A2.1 on this side, making them more square. That way, that line is a little bit lower. If you look at the page A1.2, what we tried to do after the meeting with the planning board, we had tried to come as close as possible to inwards of the exterior walls, with an exception of the location of the staircase. And we pushed in the walls about 1 foot on each side. And we also did 1 foot 6 inches setback from the front to allow for the headroom. As you see on the floor plans, which are on page A1.0, referring to the attic floor plan, which is number 4. In this current situation, the client is able to go around the bed because he has about 3 foot clearance on each side. And yet, were we able to have the headroom in the room, and the floor plan still works, even though we chopped off a little bit of a square footage from these plans because we brought the walls in a little bit, allowing for this to happen. We added, if you look at the last page, which is the page A6.0 and 6.1, we added an extra rendering just to show a little bit more of the heights and surrounding of the buildings, and showing how far that building is also set from the street. If you can show 6.1. That one here it's a rendering in color. Another change we did is that we tried to minimize the look as well. So we had used a darker paint for the upper portion because optically it will look a little bit smaller than the main portion of the house. I believe that, if I'm not mistaken, these are all the changes that we had, done, on this project, and I would like to hear your feedback.
Okay, thank you for your presentation. The next thing we do is take any public comment. And then we'll get to our. Does anybody here in the room say anything on this application, either for or against or anything? Yes, you have, if you could come up here so you can talk the microphone. Recorded for posterity.
Recorded for posterity. My name is Reg Bacon. I live at 21 Strong Street in Newburyport. Fairly new in town. I've only been here since 1983, so how could I know everything? Impossible. But even then, in 1983, it was a time when homeowners took pride in the relative authenticity of older homes and valued their contribution to neighborhood ambiance. The prideful preservation of a rundown city once defined Newburyport. But in the last few years, it seems we're headed to a future when our city will be defined by the proliferation of shed dormers and homes that have been remodeled beyond recognition. Now, I'm old enough to be long retired, but I still work in the history and preservation field, which is increasingly like being on the type wire still. So speaking of history, it was in our present century, in 2014, that our current pro-preservation zoning laws were passed unanimously by the city council. I understand the DCOD does not apply in this case, but this is a good time for a reminder that the unanimous vote by our citizen representatives was 6 months after an entire slate of say no to preservation candidates were soundly defeated. So I guess until further notice by our citizens, this pro-preservation sentiment still prevails. And speaking of preservation, there is a 21st century book on Newburyport's historic architecture, from magnificent to modest, that includes 9 Brownfield Street among the small print homes most likely to be lost to the march of progress. The planning office has a copy for your reference. Since publication of this book in 2017, at least a half dozen of these small footprint homes have been gutted, inflated, subsumed, or demolished. It's old news that escalating property values motivate the search for workarounds in zoning and permitting. So my hope is that the shed dormer proposal for 9 Brownfield Street be deemed substantially more detrimental to the neighborhood and denied. And that particular attention be paid to proposals like this in the future. Thank you.
Thank you. Would anybody else like to make a public comment in the room? How about online? Would anybody online, if you'd like to make a public comment and you're online, just push the raise my hand button. Seeing none, going once, going twice. I will close the public comment period. Now we get to questions from the board. Who from the board would like to begin with questions? Could be anyone. Yes, but
Can you review the changes you did to how much the new roof line that looks like a dormer, but it's not a dormer, how much it's stepped back from the front wall? Because it looks like it's stepped back different on one side than the other, and also different from the front to the back. Can you just review how much it stepped back? I couldn't
Yeah.
find. the
If
actual dimension.
you look at the page, where the roof plan, yes, which is page A1, 2, A1.2. The south wall is the front of the property, so currently that setback is 1'6". Going in, 1 foot further down, which is going to be, about 5 feet. Well, first it's 1'6", and there's 4'9". step into where that section with the staircases. And from the back, it is aligned, with the back wall.
That,
Yes, and the side walls, with an exception of that section with the staircase and a little bit inside the master bedroom, is that 11'5" is where it is even with the side walls. This building is only 15'9" inside. Doing anything more than this would make the room unusable. And also if we did try to put the bed on the other side, however, the window would be blocking the window that's representing the front, which means that, it could create some danger for a child, like, for example, if there was any at that time, because that's, windows in front of the bed are just not a good idea in general.
so if we go to A6,
Yes.
it shows the vertical roof. Is where the three windows are, that part, that wall
Yes.
is
Aligned with the.
aligned with the building below,
Correct,
and then it's stepped in on both sides. It's like,
yes,
okay,
by 1 foot.
by one.
Mhm.
And then the same thing on the other side.
Correct, just to make it more uniform. On the other side, there's no staircase, but,
So the three windows is where it's aligned, and the three on the left is where it's stepped back
mhm.
again. Okay, I got it. Thank you. No other questions, Chair. Thank you.
Who would like to go next on the board? Anyone? Stephen?
Could you clarify your position with respect to the applicability of the dormer ordinance, I guess we'll call it, to this matter?
Yes, as it was described in the letter from, Jennifer Blanchett, there was a definition clarifying what a dormer is, and this is not considered to be a dormer. Would you like me to read that portion?
No, I read the letter, but I just want to understand your position, not what Jennifer says your position is. The applicant's position is that A is not a dormer.
Mhm.
And because it's not a dormer, the dormer ordinance does not apply. So this is merely should be viewed as an extension of the wall, an upward extension of the wall.
Correct,
And that's what it is.
yes,
Okay.
that is correct.
Are you done? Who would like to go next? One? Go ahead.
On the materials, I wasn't here at the last meeting and I would have raised this at the last meeting. On the materials, I noticed that the cementitious clapboard is the kind with the texture. Is that what's intended, or is that just an example generally of that? Because I think typically, and maybe I'm speaking out of turn, typically I think that the clapboards are usually smooth as opposed to that texture.
Well, the rough ones slightly represent the wood texture, since the buildings back then were wood. We don't have a preference. This was what was approved by the historic board,
Right.
and they agreed that,
To the textured one, I think if you,
yeah, sure. Yeah.
the textured one, I don't think is really
It-
too common,
yeah.
yeah. I'd like to see it smooth, just because I think that's what generally, if you walk around town, the clapboards are smooth, or they appear to be smooth.
Yeah, we can take that note. I don't think there's a problem with that.
There is no problem, sir. Well,
Very good.
we have no issue with it being smooth.
Assume that's the homeowner, but just for our note taker, can you please identify yourself?
I apologize. This is Ryan Johnson. I'm the homeowner of 9 Bromfield Street, sir.
All right. Anything else, Mr.
No.
Gilbert? Anybody else? Um. Well, you three don't, maybe I have one. Although I think Blackberry will cover it. I realize the dormer regs require bigger setbacks from the front and back. And this has no setback. The front, you have 1.6. The dormer regs are higher than 3.6. 3.6. So you're just trying to keep track of it. So you're a lot closer to the front, much closer to the back. Sides are all closer. It's supposed to be a 1.5 feet. So I think Bud kind of covered this, so I don't need to be here.
It's like a hybrid
I feel
between a dormer and extended roof.
All right. So Greg, Larry, or Jared, do you have anything else before we shut? Questions from the board? All right, so that gets us to deliberations. Here's where the board, go around the table and each person talks about whether this meets the criteria, the two-pronged criteria for the special permit for non-conformities. When we get to the end of the table, we get some sense of how it's vote and then vote. That makes sense at that time. So who would like to begin deliberations?
I'll start again. Just on the two criteria, there's no new non-conformity created. So the second one becomes the hurdle is substantially more detrimental to the neighborhood. I think with some of the documentation that's found, I believe that the planning board has decided this is not a dorm. Well, I guess
I think it went to the historical.
Yeah, just to clarify.
in plain text clarification, basically saying this isn't a dormer, don't call it a dormer.
Just like interjecting.
Yes.
Playing off. Okay, not the board, the office.
Zoning administrator, just clarifying, I think just, there is a distinction between two different sets of regulations here. Whether or not it's a dormer, and I'm not sure I would say it's not a dormer as much as I would say it maybe it's not a dormer that qualifies for the allowance that's specifically cited in the definition of play ordinance.
Okay.
Just to be clear, as far as what we say, it's not a dormer, I think it might be not an accurate sort of depiction. It is a dormer per se, or it's an upward extension, however you want to refer to it. I think that what's being pointed out here, perhaps, just that it doesn't meet the qualification for a dormer that is exempt, so to speak, or allowed at the beginning of that set of regulations.
Okay. And so with that said, I believe we're not going to treat it as a dormer within our ordinance. And that it is just an upward extension of the roof. So with that, in my opinion, it is not more detrimental to the neighborhood. It is an extension of the wall and it is a raised roof. Some could argue that might be detrimental, but I guess I see these all over the place. My house included, the one I live in. What we would have called in the old days a shed door. And it's an 1850s house. It's not visible from the street, but it's still. So I would say it's not more detrimental, and with that, I can approve this application. I think I said as much back first time. I like the fact that they moved it a little bit, it gets closer to what we would have liked to have seen if we were calling it a dormer as per the ordinance. So I appreciate that. But I don't think it's significantly more detrimental, so I would
Okay, thank you, Mr. Shetton. Like to comment next. So many silence, yes. I go next, but I have to go last.
To be honest. So I think whether this is a dormer or not, the question is the issue. It's the neighborhood is it's when we take into account fencing, and it's homes or not with the neighborhood. I think this is an improvement over the iteration. I know what we has to do here is to balance the property owners' rights. The directive, zoning ordinance. Which states, this special should be granted unless we should substantially more to the neighborhood than what is there. Got to stroll around. I take Megan's comments seriously and keep mindful of the future of the community. I am following my screen. Get to the superintendent. Brad. We got,
And stop at 10.
okay. Also, somewhat taken by the historical commission's approval of this. Lack of any real direction or definitive comments on the historical nature of this. I think that's disappointing to me. We're not bound by that, but certainly I take that very seriously, particularly in their field of expertise. So all that being said, I come to the conclusion after this rambling exegesis that I do not find this to be a substantial detriment to the neighborhood.
Okay. Larry or Jared, chime in here?
Yeah, first I want to clarify, given Jennifer Blanchet's speaking for myself, I don't believe that there's any mandatory. I never did. Instead, all we're trying to do here is side with the substantially more detrimental to the neighborhood than like. We mentioned the dormer, or at least I mentioned it, urged the applicant to try to get closer to them. They made an effort, some effort, but I think it still falls short in that I think it is substantially more detrimental. Although it's not necessary to give particularized reasons, it's only fair that I give them. First, it was described as a third floor vertical addition in place of the existing attic floor, so the record. Personally, I have to use my judgment. That we're a discretionary board. My judgment, it would intensify, exacerbate the existing non-conforming structure and be substantially more detrimental to the neighborhood than the pre-existing non-conforming structure. Personally, I considered among other relevant factors, size, scale, massing, volume, location, as compared to three things. First, as compared to the existing structure and the existing lot, both of which pre-exist the zoning code by at least 50 years. So the house encroaches into the side setbacks and front setback. Lot has 29.3 linear feet of frontage when 90 is required. It's 2,164 square feet of area, 10,000 is required. Second, as compared to other structures and other lots in the neighborhood, it made a site visit, didn't just study the street map, the Google Street View. I actually went to the site and walked around the streetscape. My finding personally is that other buildings in the neighborhood are predominantly pitched roofs and attics, just like this. Also, the other lots in the neighborhood, from studying the GIS, they're generally larger slot, but 2,460. I want to say for the record, to me, the neighborhood quote, neighborhood is larger than just this lot and the adjacent lots. It's the streetscape. Either side of Bromfield Street, south. Water Street is a different streetscape. Just talking about Bromfield. Third, as I think we're supposed to under the code, I considered reasonable alternatives. Now staff in the previous report, they're the ones who pointed out the originally the dormer guidelines. Then I and other board members, those are the only ones, suggested you could study a third floor addition that comes closer to guidelines for the dormer. And I see the drawings have changed, so I'm not discounting that there's an effort made. I don't think it's there. At no time have I ever expected strict conformance with those guidelines. I'm trying to make a judgment based on whether this third floor addition is substantially more detrimental. And there are cases where extension like this would not be facts, even here. I think it is. And for example, like mentioned, the shed dormers are not common. One on his house isn't even visible from a public way. This would have two. Not just one. We did recognize, we specifically talked about, we know that the applicant wants to put in a new staircase, and there's certainly on the side of the staircase. There's no way they could set back the, or any, but that's one side. Yeah, there's no setback. So I'm sorry, I definitely want people to be able to improve their house because they want to get better use of the existing attic. But this design doesn't meet the standard. In my opinion.
Thank you. Thank you. Stephen,
I mean, I've been struggling with this equipment. I watched it online. Part of the reason I have a problem with this is I was on a council that not do something. And I know we're saying it's not a dormer, but I don't see it. It's two dormers. And I think that's neighbors. We could call it upward addition, but you see two dormers. It will be part of that. Makes that house bigger. More mass to it. It's just my general thoughts. I mean, I'm not a voting member tonight on this. It's just those are my struggles.
Stephen,
Yeah, so I'm gonna agree with Larry and Jared that I think this is substantially more detrimental. Reasons that Jared already articulated. I think another reason in that is that this is a structure that is on the district data sheet as a contributing structure to the historical of the streetscape, as Jared mentioned. So the dramatic change to the roof line is difficult for me to support.
okay, thank you. In my own comment, I kind of went back and forth with the planning department on this week. And I learned that the dormer regulations are something that's regulated by the historic commission. When they looked at this, for some reason, they thought it was fine. When I look at it, I guess I'm supposed to look at whether an upward extension of all the walls is more detrimental and creates more massing, et cetera. But to me, the dormer regulations are a handy, a tool that can reduce the apparent massing. You just took everything straight up. You'd be putting a whole top floor on. Instead, you're carving it back some way you're saying you are making it. And I realize we're not technically looking at the dormer regulations here, but for me, if it came closer to the dormer regulations, it wouldn't look so massive. And yeah, I think you can point to a couple other houses in the South End that have done this, but you have to. So why the zoning board of appeals has been more stringent, trying to prevent even more of our historic laws. So anyway, I think Jared said it did well. It was echoed over here and I agree with him. So what you have, voting members, you only have 2 out of 5 and you need 4 out of 5. So, if we were to take a vote right now, it would likely fail and you couldn't ask for anything for 2 years. So at this point, we ask the applicant if they have the interest in continuing the application, seeing if they can take the information that they learned tonight, maybe get something that's closer and get more votes. And I want to also echo what Jared said, I'm not asking you to meet every piece of the voting regulation, but it's still way too far away. Move. My question to you is, would you like a continuance or would you like us to move?
Like a continuance.
You have any idea how far you'd like to continue? Joppa can Caitlin can be looking up when we have an opening too, because we have a lot of things coming up, but we have. So, Caitlin, when do we have an opening?
September 23rd.
Would September 23rd be convenient?
Yeah, yes, sir. We'll take that date for now. Thank you.
And I have a motion from someone to continue this to September 23rd. Is there a second? Okay. So it's been moved and seconded. And, we'll go down the table. Mr. Delisle?
Yes.
Mr. Bennett?
Yes.
Shagnon?
Yes.
Yeah.
And Mr. Ivory?
Yes.
I vote yes. So it has been continued. Thank you very much. Now we can get, leader back in here. Matt.
Yeah, couldn't hear anything.
Okay, our next application, this is a new application, Susan Daly and Anthony Hoggood, Lisa Mead, Keller, Wayne Costa. This is the application for 164 Old Point Road. This matter is, I'm sorry, it's continued from September 22. The applicant seeks all necessary permits and permission and approvals for a special permit for nonconformities to renovate a one-story home into a two-story home. Attorney Mead.
Hi, thank you, Mr. Chair, members of the board. For the record, Lisa Mead, Town Costa, 33rd Street, and your report on behalf of Susan Daly and Tony Hogwood, and Tony's with me this evening, and Eileen Graff is the architect on this project. Go to the next slide. So Susan and Tony would like to renovate their existing single-family home, which is at 164 Old Point Road, by removing a later added at-grade front porch that was later enclosed and made into living space, and adding a second story over a portion of the remaining home. The property is in the R3 zoning district and the Plum Island Overlay District, and was constructed around 1948, according to the assessor's records. You go to the next slide. There's no Form B. Proposal required a demolition review by the Historic Commission. It was determined not historically significant by the commission. It also required Conservation Commission review. And last week, the Conservation Commission issued an order of conditions on the project. And so they approved the project, what you're going to see here this evening. Next slide, please. So here's the property. If you go all the way to the end of Old Point Road, and you kind of look up on the knoll, this is one of the higher points on Old Point Road. In the middle of the lot is this. This lot actually contains 2 structures, 2 homes. And so it contains 3 structures, but 2 homes. They're actually condominiums. And so when you calculate the FAR, which we're going to talk about in a little bit, we have to calculate all of them all together for the property. But this structure, Susan and Tony's home, is in the middle of the property, and it's the front one towards Old Point Road. I'll also point out on this that you're gonna see better on the site plan. This is actually surrounded by 4 streets. You can't see them here, but they exist. And so, it actually, when you see the front yard and rear yard, and side yards, it's a little confusing because there's actually 4 streets all around the lot. But their property is right in the middle. You can see that rectangle towards the front. That's that 1-story porch that was added on and is at grade, which is gonna be removed. And so that's kind of the overview of that. Next slide, please. So the property has a number of nonconformities, not surprising. The property's lot area is 9,226, where 12,000 is the minimum. The current lot coverage is 22%, where 20% is the maximum. We're proposing to improve that to 18.6 and make it compliant. That's as a result of removing that whole section in the front. The front yard, left, right, and rear yard setbacks are all non-compliant. They're 8, 5, and 8 feet respectively, where 20 feet are required. We are improving the 5'1" to 8 feet, so we're making a little improvement there. The FAR for the entire lot is 0.252, so it's over, and we're proposing to make it 0.27, where of course 2.5 is the maximum in the ordinance. Also, because there are 2 homes on the lot, it's non-conforming. We don't create any new non-conformities, and otherwise the property conforms. The open space also, I might add, will be improved on the lot from 79.6 to 81.3%. Next slide, please. So as you know, as we said, we're going to add a 2nd story. If you go to the next slide, please. So here's the site plan, and if you could just blow up the middle picture a little bit. It's a little hard because it's in red. The new structure's in red over the what's going to go away. So if you see the kind of the gray hash line around the entire structure, that's the existing structure. And then the gray rectangle in the front is what's going to be removed. And you can see the proposed 2nd story is kind of an L on top of that, and that black metal area, the metal part in the back is going to be 1 story. So that's the proposed 2nd story around it, and then you've got the front part that's going to be removed. You can see the improved rear yard, side yard setback, which is in the back up to the right-hand side, which is currently at 5 because of the front addition. That's going to be removed, so we'll go to 8. Otherwise, the setbacks will stay the same. Next slide, please. So here's a picture of the house from Old Point Road. See it there. Looking up. Next slide, please. And here's another, and you can see this is the front porch area that's going to be removed. That's at grade with that door there. That's the front section of it. Next slide. And there's the sidewalk or the boardwalk on the right-hand side actually leads to Queen. That's Queen Street, and there's a house in the back, and that's how they get to their house. And Tony and Susan's is on the left-hand side. Next slide, please. And here's one of the side photos. Next slide, please. And then this is off the back. Next slide. And then we have around the corner. And next slide, please. And then again, this is towards the back, or where the entrance on the front side there. Sorry, that's the side. Next slide, please. And then this is just how you can see you can get to the Bauman's in the back. If you keep going down the sidewalk, that's the Bauman's own the other house on the property. And the house at question is the one on the front right side. I might also add one here, just to give you an idea. This is actually outside of the floodplain. So the elevation for this property is on different corners of the house is 14 to 16 feet, as opposed to the elevation at Old Point Road, which is 6.4. So you can see how it goes up. So the only floodplain on this entire lot is actually on the front left portion of the lot, as it is at Old Point Road. The rest of the entire lot is outside of the floodplain. And with that, if you go over to the next slide, I'm going to turn it over to Eileen to go over the architecture.
So, fitting, So as Lisa's already helped orient you on the site, photographs sort of orient you on this, what I'll call kind of quirky structure. As you can see in the photos and on the top two drawings, those are the existing front and side. There's sort of this curious, very rather flat front shed piece. And it's about 9 feet off of what I think was the original footprint, which is approximately 30 by 28. What our goals were with this design was to try to essentially shift some of the FAR that they have in the structure with a very slight increase by moving that square footage that was in the front porch or front addition, I'll call it, and moving it to the second floor in order to allow them to have something that's a little more productive. The other thing that, as Lisa mentioned, that front piece is on a slab. It's also about 1.5 feet lower on the finished floor than the rest of the house. So that's another area where it's a very difficult space to try to improve on to make it one continuous level because it has such a low ceiling height in there. So again, shifting it to the second floor, allowing it to be more comfortable. While we did this, we paid close attention to the existing structure. So that helped us inform the living space that we put on the second floor. And by that, I mean, we were looking to be economical in the way we structured this thing down through the building and some existing bearing walls. So that helped us determine the proportions of that L shape that you see on that second floor level. In doing so, we then tried to bring back some steeper pitches that might be more typical of the cottages that we would see on Plum Island. And more bring it more towards the vernacular, the context that is surrounding this property, as opposed to these very, very shallow sloped roofs that you see on the existing structure. So the bottom left is the new front facade. There's a covered porch there connecting to the existing front paths from the parking area, and which leads you to that low point that Lisa was referencing as you enter onto the property. As you can see on the back, the bottom right drawing in the back, that back deck is going to remain. The only thing that is being changed from that existing back deck is that there was a vertical panel screening that conservation wanted removed just for because of due to its location. So there are a couple panels down there, but otherwise that will be removed, but otherwise that will remain intact. The goals are to also bring the fenestrations to a more cottagey feel. So we propose double hungs in a high-end window with a 6-1 division pattern. Again, typical of the cottage style. Again, using some sort of playfulness. We have some small square windows on the upper left dormer there. Maybe we can switch to the next slide just to show the other two elevations. And here again, you can see some of the steeper pitches to just bring that nod back to the sort of cottage form and the front covered porch. And here as well, you can see the existing rear deck that would be remaining. As far as materials, we intend to have that be re-sided with shingles, architectural roof shingles on the rooftops. I mentioned the windows that are being proposed. Some will remain. There are a couple of quirky locations that we don't intend to disturb an existing bathroom. We have a few that will remain, but otherwise most will be replaced or added. But in summary, the proposed structure is really trying to create a more compact form, lightening its sort of low impact on the site. Conservation is happy to have more open space to then help with replanting of vegetation. And in our point of view, the character, the lines, the materials, portions of fenestrations help give it the character that's more sympathetic and more typical of what you would see in the neighborhood. And with that, I will let Lisa close out the presentation.
Thank you, Eileen. So if you can go to, skip the floor plan, I guess I would tell you that currently there are 3 bedrooms in the home. And there will be again 3 bedrooms in the home. The 3 bedrooms will be on the first floor and then the living space is gonna be on the second. So thank you. So we're here under the PIOT, so special permit for nonconformities. One, the first criteria is that the proposal will not be substantially more detrimental to the neighborhood or the PIOT than the pre-existing non-conforming structure. And the proposed changes can't cause the structure to be within 10 feet of the sidelines or more than 2 stories or 35 feet in height. So as to the second one, we meet those requirements because we're not changing the existing conditions, which are the ones that offend the 10 feet. As to the first one, it won't be substantially more detrimental for the following reasons. So basically, it's about the increase in FAR, and the increase is 0.018 to 0.27. That's 139 square feet, just to give you an idea. So the house will be 1,448 square feet. That's the resulting structure, just to give you an overall size. So it's quite small and compact. Next slide, please. We believe that the structure will not be, sorry, and you go to the next slide, please. The structure will not be substantially more detrimental to the property. First, we remove nonconformity by decreasing the lot coverage. And that is now in conformance with the ordinance and improves, we also improve the open space on the lot. This is important, particularly because there's a high point here and it will help prevent runoff or any kind of sloughing later on. It helps decrease the impervious area and reducing runoff. We also improve the side yard setback by 3 feet. Importantly, remove that at-grade front section from the sand, right? I think that's one of the big things that the Conservation Commission really appreciated was the removal of that section from being at grade. And that was an improvement certainly by their standards. And we think that the 139 square feet is minimal compared to the trade-off of removing that front section. And while it does increase the FAR, we think that it's certainly not substantially more detrimental to the PIOD than the existing conditions. And in fact, as I've said to you, we actually improve the conditions related to the PIOD. It will continue to have 3 bedrooms, which is what's required, that we can't go over that. So that won't change. And I also say to you, it's also going to be consistent with the surrounding neighbors, and I'll talk to you about that in a minute. I did list we have 6 letters of support that I already submitted, and I listed those. You go to the next slide, please. So we have all the surrounding properties have issued letters of support. In addition, Tony delivered to me tonight, and I'll give them to Caitlin, 2 other letters of support, 1 P Street and 155 Old Point Road. So that's 8 letters of support. That's certainly all of the surrounding neighbors and then some. Next slide, please. So then it's consistent with the neighborhood. So this is the old 164 Old Point Road rear. So that's the house in the back, and the Baumanns have supported this project, obviously, because it's a condominium and they have to in order for us to be here. Next slide, please. And so this stands back a little bit, so you can see that the properties in this area are mostly 2-story, rather large. This is going to be quite small compared to the rest of them, but it's certainly going to be consistent and not substantially more detrimental to the neighborhood than the other existing structures. And I think I might have one more, and here's just kind of the other side of the circle. So you can see there are 2-story structures all around it. But for the Baumanns in the back, that's closer to the water. And with that, I'm happy to answer any questions, and we request the board issue a special permit for nonconformities related to this project.
Good. Thank you, Attorney Mead. Does anyone in the audience wish to speak during public comment in connection with the application, either for or against, or just simply share your thoughts? Please raise your hand and we will recognize you. Seeing no hands, we'll go online for a moment, and we only have a few folks logged in. Anyone who's listening online that wishes to be heard, just kindly raise your virtual hand and we'll ask you to unmute your mic. We'll do the same. Here from you. Seeing no hands online, once more in the room, we'll close public comment and questions from the board. Yes, Mr. Swan.
Hi,
Could you put up slide? Just the existing floor plan, I just want to try to understand what's happening in the park application. Down on the bottom right, it says the basement has 201 square feet. So I guess up there to the bottom. If you go to the next page, that office has become storage, and there's a note, I think it says that the drop ceiling has been lowered for proper insulation, and down at the bottom, the basement floor is on the ceiling. Because the headroom is below the level at which it counts.
Incorrect, yes.
I see. Okay, so I'm not trying to make a big deal of this, I'm just trying to understand. You did mention that you were taking the first floor and putting it on the second. You're also almost taking this area that used to be an office and adding that to the second. So I guess my other question related to that is, you could have maintained the same square footage. You mentioned it's only 139, if you did put storage room and porch going away. You could have gotten there and at least maintain the same square footage by having a 139 square feet less. Just, did you consider that? When you look at them that much? Do your second floor.
Absolutely, that's a great question. So again, some of the things that we wanted to do was propose an addition that was cost effective too. We ride that balance of the percentage of money put in towards the building, right? We knew that there are bearing lines that existed. If you look to the left drawing, you can sort of see the center bearing wall. That helped us understand the location that we could have structure. So that to us was helping determine what the width of the second story was in the top right drawing. Likewise, it did the same on the left corner, extending sort of bearing locations in the same way. So could you get down 139 square feet and still connect to a second level that has a staircase, which it currently doesn't have a staircase because it's only one story. That space that you see in the basement is only accessed from the exterior. So it's really a very difficult FAR that we have to count due to, because it exists, but it's not practical space for this family. And so with trying to absorb that FAR from the basement space, and bringing it back to conservation doesn't want that space down there either. So, and we don't. So really, combining all of those conditions, we felt it brought us to the second floor, and inadvertently due to structural lines, we end up at 139 more. And it's a very cost-effective, in my mind, a cost-effective way to get that space at a second floor area.
Okay, thank you.
You're welcome.
Any other questions?
What was the square footage, or what is the square footage of the to be removed porch on grade? You know,
It's about 9 feet forward and about 30 wide. Yeah.
Great, thank you.
Any other questions?
Yeah, I just want to follow. Just to, so I understand is the proposed structure here much larger than the existing structure?
139 square feet.
Yeah, explain to me again why the Conservation Commission applauded your
So, because that rectangle in front is built into the sand, and so by removing it, it's less building in the sand. And so they want things to move.
Yes. Anyone else? Great, I don't have any questions either. I'll close questions and we'll go into deliberations. And, again, we're deliberating the criteria for the special permit plan forwards. Who would like to? Plus the prompt and begin the deliberations.
Well, this time I don't vote, I can go first.
Please, thank you.
So using the same methodology that I used in my previous case and all the other cases. What's changing from the existing structure is really they're adding a story. That's all. I mean, 139 square feet is de minimis in my mind. They're also, especially because there are multiple buildings on this lot. So the increase is, 0.18 of FAR where the cap is at 0.25, just not, that wouldn't be noticeable really to the public. It's the second story noticeable. Also, I think it is relevant. So there are other things that we should take into account other than size, scale, massing, volume, and location. Another relevant factor is floodplain. And so those were important facts. That the building's actually not in a floodplain, but changes are better for dealing with flood. You definitely don't want to have an office that will, it's just not a great idea. So that's good. It's being moved. Another important fact to me and why it's really just all about the addition is because if you have 3 bedrooms already, you can't add any more bedrooms. They're not adding 3 bedrooms now, not 3 bedrooms tomorrow. So, in my mind and in my personal experience, the more bedrooms and bathrooms you have, it means the more people live there, or a strain on the neighborhood and the infrastructure, mainly because of cars, to be honest. But there isn't any here. It's just living space. So again, what I get down to is this second story in the context of this existing building and the neighborhood substantially more detrimental than it is in my mind. This is not, this is why we have to do individualized determinations. This is not Bromfield Street. This is a totally different neighborhood, different things going on, different environment, different prevailing neighborhood. I just can't, I personally can't see that this is substantially, that there's some substance to saying it's more detrimental to add another story. Frankly, driving around the neighborhood here in Plum Island, I don't really think most people would notice the difference with the second story. So if I had a vote, I would support it.
Yes.
Yeah, our 2-prong test, there are no new nonconformities, maybe an improvement one. With coverage. We're also reducing a setback, which ultimately is significant. Normally, I don't like, Attorney B knows, I don't like increasing over the FAR. This one was already marginally over the FAR, now it's a little more over the FAR. But I also agree with Mr. Ackerman. If you look around that particular neighborhood, it's mostly all 2-story buildings. I don't think this one will be out of place. I don't think it's more detrimental. Plus, it's rare we get that many letters from the butters. So I think that's also significant. Anyway, for all those reasons, I can.
Very good.
Yeah, I agree with Mr. Swanton. I think the reduction of the footprint of the building and getting that first the portion of the first floor that was on grade, getting that out of the sand is an important fact here. You're improving the lot coverage and open space. I guess trade that for a bit of FAR. I don't think the addition of the second story would be substantially more detrimental to the neighborhood than what exists currently. So I can support this.
Anything further?
I agree with. Removal of one nonconformity to the criteria. I might say though that although two-story structure is complementary to the neighborhood. I find the existing structure somewhat quirky and appealing in some,
Of course, you do.
Plum Island way. That's being lost. This is just another example of that. So, but nevertheless, the reasons are typical. It's,
Thank you.
I'll just chime in. I have to agree, and I think as Mr. Swan said, the fact that you have 8 letters of support, might be hard for us to say that. If you've got 8 neighbors saying, I can live with this, that's pretty solid. And it's probably not more than. So that I have support.
So substantially.
Yeah. Exactly. A bigger.
Anyone else? Wish to chime in? I'll just say I do concur. I can't have anything else to say. Unless there's any further deliberations, I will close deliberations and entertain a motion. Second. We have a motion to approve.
I'll make a motion to approve 164 Old Point, DNC 25-16.
Second. Mr. Shannon, second. Mr. Swanton, calling the roll. Mr. Swanton.
Yeah.
Yes.
Yeah.
Shannon.
Yes.
Yes, it's 5 in the affirmative. The ayes have it. Motion carries.
Thank you very much.
Congratulations. Good luck to you.
Thank
Thank
you.
you. Have a great evening. We have the final application and hearing this evening. This is the application Reef Green, 5 Dawes Street. The applicant seeks all necessary approvals, permissions, and permits for a variance to construct an accessory structure requiring relief from the side and rear yard setbacks and lot coverage. May we hear from you? Good evening.
Good evening, Ann Whitney, architect, helping greens out. Yes, this was an interesting property in that back in 2005, this same request was brought before the board and was passed, but never built. There was the immediate abutter to the left that had some issues, went to Superior Court. I think it never came of it, but the approval was continued. The first plan, yeah, as you can see, that's the the map showing the lot. You go to the next page. This is the original plan from 2005. Was done. Since that time, there have been some landscape improvements and changes to the driveway. So if you go to the next plan, shows how the current driveway lays out. And I did some recalculations for the matrix. Also between 2005 and currently, we don't know when that happened. There was a little shed attached to the left side of that garage, 44 inches by the full 20 feet. So we're proposing to remove that. And that currently has a setback of 3.7 feet, 13.7 feet. Basically, we have a structure that's non-conforming currently as to the rear, and then with the addition, it would be the rear and the side. Also, a slight increase in the coverage. Plans, you can see the floor plan there. It's a little hip roof structure. Currently, the 2 garages where I have a person door, that left drawing, garage door there. When you see in the photograph, it's really hard to maneuver into that opening. So by adding this second bay and extending the hip roof, that area can just become a storage area or kind of be more part of the landscape part. So we'll basically just be taking the old hip roof structure and just extending it with another hip. A couple of windows added on the right-hand side that looks out into the yard. And there's a couple of existing windows at the back of the property that just remain. And there'll be no windows on the non-conforming side where that shed was happening. Currently, it's sided in like a, it was called a Dutch lap, that was the sheathing and the siding. Most likely, we will be, siding over that because it's not very tight. Because of the proximity to the property line, at least the rear elevation would have to be like a hardy plank, fire retardant. We're over 5 feet on that left side. We could just do clapboards on that side. And the photos show the current condition of the property. The other, when we go back to it shows the front elevation. One of the changes to the driveway was that they've already paved. We're not gonna have to change the driveway to add that thing. The paving has already been adjusted to create that space there. We feel that this is a reasonable request, and this was passed in 2005. Another approval.
Very good. Thank you. Was there anything for?
I think so.
Just didn't want to cut you.
Actually, one thing, I'm sorry, it was added to the file this afternoon. We go back, actually there's one other drawing, the last drawing on your, shows the, I think there's one more drawing that shows this one here, and you have that. There it is. Yeah. This, and I just took my map, kind of got it to scale. You can see where the garage is located in that corner, and it shows some plus or minus. My map is totally accurate, plus or minus to other structures. And on the Dawes Street where this one enters, we have signed approval from the left, both the left side, and then the one behind. 141, 142, they've been waived. We have support neighborhood. And there is, some nonconformity for these outbuildings, fairly common. The edges.
Thank you very much for the presentation. So we'll close the presentation and go to public comment. Seeing only 2 folks in the audience, do either of you wish to speak in connection with the application? We have one individual online, and so I'll just say if there's someone online that wishes to speak, please just let us know. We'll recognize you. Otherwise, we'll move on. And seeing no hand up, we'll move on and close public comment, go to questions from the board. Anyone have a question? Yes.
Yeah, I had 3 questions, just mostly confirmatory. So first, just to clarify, there are gonna be 2 garage doors, so it would still be a 2-car garage, basically just
Yes.
shifting it over and then using the right-hand side for storage.
Yes.
Okay, all right, that's 1. 2, you're not asking for any state building code relief. You said you're gonna do the hardy board, and so.
Yes.
You think you won't need any state building code?
I don't think so.
Okay, all right.
And it's a non-tempered building, but I think we just.
And then a 3rd question, you mentioned some letters in support. I didn't know about the litigation to the left. So are those the people that are out of town?
Yes, no, those are the ones that are supporting it. And
Supporting
actually, it's the son, the person that opposed it, it's the property's been passed on to his son, and he's very supportive.
Okay,
Yeah.
thanks. That's fine.
Question, when the 2005 approval was obtained, was the side setback the same as it is now?
Yes. The reason there's a difference on my matrix is that they built that somebody somewhere between.
Oh, I'm sorry, I misspoke. not the requirement, the setback, the required setback, not the actual setback.
I don't know, you might have to ask the planning here.
Did that change recently from 6 feet to 10 feet? Is that why we're at 10 feet?
I think it's because of the size of the structure is over.
Well, that was one of the changes in the, a couple of years ago, in the side yard, mini
Dimension.
Yeah, 10 feet, 6 feet, yeah. Okay, so when the variance was obtained last time, it was basically a variance on the lot coverage, and that side setback variance was, they were asking for a variance of 6 inches, right? 'Cause
Yes.
it went from 6 feet to 5.5.
Yeah.
So now we're asking,
5.3 in the worst case. Yeah.
right, so now we're asking for a lot more.
Mhm.
We're going from 10 feet.
Mhm.
I have a question. Yeah, leave the site. Yes. Typically with a variance, we typically look for somebody to have hardship where there's, either it's a shaped lot, this is a rectangle. Or the topology, you know, it like slopes in such a way that that's the only place you can put something.
Right,
But this is a fairly flat lot, so,
right. I think the main hardship is, the location of that right side garage door makes it very difficult to access a vehicle. And,
I'm sorry, could you show the picture of the?
yeah, front of the,
So that.
and you can see the dashed lines, those are the doors that we're removing and then the structures. Yeah, so that, when you come in, you have to kind of go around the house. And it's like at least a 3-point turn, or you have to back all the way out the driveway.
You can kind of get that sense in the picture. It's make to get into the right hand,
And then to get into that right-hand bay, it's very,
go back and forth a few times.
yes. Or you just have to back the entire way out, and it's a very long driveway.
I see.
Yeah.
The other typical thing we run into in the variance, like soil conditions, like if it's wetland in other places, but I guess.
It's pretty flat site,
Yeah. All right. Thanks. I didn't have no.
Any other questions? Yes. No, Will. So variance is a hard hurdle for us to get over versus a special permit. Did you consider shrinking the building from what you're asking so that you wouldn't encroach on the side yard setback? You only have to shrink the building by 5 feet.
well, then you couldn't have a second garage,
You could, you just have to move both doors.
but you still have the issue of,
Not,
the turning.
not too much, because you go out 7 feet, right? Your left door is only 7 feet wide. The other door is, like it lines up okay, pretty close.
Actually, we're looking at trying to do 9-foot doors.
Big doors.
So, you know, your standard door size.
Yeah.
Yeah. Current ones are 8-foot doors.
But it's small.
Yeah.
It's just for a little bit smaller building, don't think you need a variance. You can do it.
But when you have, yeah, the space being usable, and I think it's mainly just the accessing both those spaces.
And
Yep,
that second bay to the right is impossible, there's no way to get. Right, what you're asking for is a 32-foot wide garage. That's massive. In Newburyport. If you shrunk it 5 feet, so it'd only be what, 27? You wouldn't need a variance. From the lot?
well, we still need a variance for, the rear setback.
No, you
No.
need
Not
the
here.
lot coverage, and you might be under that.
And I think you'd be under it because you'd shrink the building enough.
Well, the rear setback is only,
That's existing.
It's existing.
It's not something.
well, yeah, well,
You won't make it worse.
we won't make it worse.
Right,
It'll
so I
still
think-
be under what's required.
Right, so I
Yeah.
think I think the fact that you're creating a new side yard setback and the lot coverage requires you to go to a variance. You got rid of those two by shrinking the building. By 5 feet. Right, the side yard setback's 10 feet, you only have to go,
But if you're under a certain square footage, your setback would be 6
it
feet.
goes to 6.
Right.
So,
We're still gonna be over that.
because 32 by 20 is a big garage. Where it seems like you should be able to, I know it's a pain in the neck to move garage doors. Because you might have, I don't know if you got valley columns in the middle of it. But you wouldn't need a variance. You're here for variance. It's just a tougher hurdle.
Right.
We grant very few variances. Again, like Ken said, unless, you got a sloping yard, and it would be nuts to go out the left side, you go out the right. We say, okay. Or if there's a, I don't know, massive tree in the way that everybody loves, that might be another one. This is a flat lot. You got plenty of room. And it's just that it ends up being a big garage, 32 by 20.
The depth is pretty minimal.
Yeah, 20 is probably the minimum. What's a standard garage? 24 by 20?
24.
Yeah,
Well, actually, it's bigger than that these days, because it's keep getting bigger.
yeah, you can't have a truck.
Yeah.
No more questions, Chair. I'm good, thank you.
Okay. Any other questions? Seeing none, we'll close questions and go into deliberations.
What's that? Oh, you just,
Description of the chair, I'll be
Yeah.
happy to hear this.
yeah, go up.
I'm Reed Green, the owner of the home and garage. That second bay is like impossible to get into. It's built behind the house, and then the left-hand bay, the right-hand side of the left-hand bay is even with the side of the house, dead even. So you have to pull out the car all the way out of the left-hand bay. And then as soon as the nose of the car clears the right-hand side of the garage, you've got to cut it so you don't hit the house. So the right-hand bay is really storage space now. It's impossible to get in, so. We've been there since February, and this is how we found it. So if you shrunk that in any way, it really needs to go out to the left, because doing anything to the right is just non-functional. And I'm sort of clarify that. We really seen from this photos. Okay. Thank you, sir. Thank you. Okay. Driving our deliberations, we start. Who wishes to begin?
I'll begin. I guess we start with the proposition that the zoning board approved something before, however. My colleague, Lyle, points out that regulation and a variance granting a 6-inch turn 9-inch belief is a far cry from this request, which is nearly 5 feet. So, as much as I would like to bring some precedential value to the early zoning decision here, so that brings us to the criteria evaluate and grant. As Mr. Swanton has indicated, well, there's no presentation that comes anywhere near the requirements to support the grant of variance here. Highly constrained grant. It's a rarity to be granted variance. Even if I were I, special circumstances here, I can't conclude that the lack of a two-car garage creates a substantial hardship. So that being said, given the fact that the variance criteria is not met here, it's important to motion.
Yes, Keith?
I'm going a little bit of a different direction here. You know, you're looking for a variance and you're stating there's a hardship here. I think the hardship is that you bought a house that doesn't have a functioning two-car garage at all. And you'd like to have a functioning two-car garage at your house. So I would lean in your favor on this one because other than that, you just have a store, you have a very big storage shed, very close to your neighbors instead of a functioning garage. And if this addition would allow this to be a functioning garage, because it's not going to leave the property, so your neighbors are still going to see it tomorrow. We're not building it new. If it's not going to be a functioning garage, you know, that's where my rub here is if it's going to stay, it might as well become a functioning garage.
Any further deliberations?
Okay. I have a hard time supporting this variance. I think Mr. Shagnon kind of got me thinking that, you know, your basic problem here is you're getting close to the lot. You're supposed to be 10 feet off the lot line and you want to build all the way up to like point. And I thought his line of questioning, basically, you could, you know, maybe like over here, maybe instead of going 12 feet, you did 5 feet less, you went 7 feet. I know you have two doors in the front. If you want them the same size, you're gonna have to move them both. Put the new one here, and put the other one here, and then you have some storage left over there. It just seems to me like you have an alternative, where you're not gonna trigger a variance as far as the sidewalk setback. I don't, first of all, it's not really a hardship, it's a lot, it's regularly shaded, it's flat, it's got decent soils, but you also have an alternative, it'll still get you two-car garage. And let me just finish. And it's also not a right in Newburyport for everybody to have a two-car garage. Very few of us do. Very few of us have a one-car garage. So I mean, it's. What's that? Parking spots. I realize you bought a house, you like to do this, but I think he was pointing out there is an alternative that could get you a two-car. I have a really hard time with variances anywhere. We pass very few variances. We mostly do special permits where people aren't creating new problems. And, anyway, I can't support this.
Anyone else wish to speak? Yes.
Go ahead. Thank you. Yeah, I would just want to build on what Ken said. You don't have a hardship, in my opinion, because you have these alternatives. And the alternatives, you know, might be less pleasant than the plan that's proposed, but they exist. And it's probably an exercise going back to the drawing board and seeing what you can come up with to put yourself inside of the dimensional requirements that would allow you to do it with a 6-foot setback. And see what you can come up with and see if it's a viable plan. Otherwise, I don't see how you meet really any of the 4 criteria.
Yeah, this was actually one of the more difficult because it's really hard to reconcile what you think is a, you know, what a layperson would think of as a reasonable request to the fact that we're constrained by law. And the way I always think about it is, well, what if someone were to challenge this? So, I think though that you're not, there's no hostility to what you're trying to do. I'm a little bit, thinking, pretending I'm, the argument that there's a hardship because others in the neighborhood have two-car garages. Not everyone has a two-car garage in Newburyport, but I'm gonna argue in the neighborhood they do, and therefore, I can sort of, through sophistry, get you to hardship. But I think the path forward here, I mean, look, we want you to be able to park two cars. We're not trying to make your life miserable. But we just don't have, it's just not lawful in our mind for us to give you a 32-foot wide garage that gets so close to the lot line. So, if we had a magic wand, you could pick up the garage and move it to the left. We don't have a magic wand. But I suggest, I don't have a vote, but I suggest you could try to redesign this, so at the very least, you're getting less of a variance. I was looking at our code, many zoning codes say when you grant a variance, it should be the minimal difference. Ours doesn't quite say that, that's all kinds of other gobbledygook, but I think that's what we're getting at, is that we're not saying hell no, we're saying it's too much. This is too much, it's not, we can't support it.
Very good. Allow me to say, folks, this is usually the time when we get to an application such as this where I sort of force a pause on us, and give you the opportunity because, this is an intersection beyond which, if we should continue, we would go into a motion and a second and then a vote. If the vote is, as it appears it would be, there's no secret in the polling straw that is of the board, that it does not meet muster at least 4 votes that are yes, then it would fail, and that could bar you from bringing this application in its current form for up to 2 years. So rather than that ambush you, as it were, I always want to give an opportunity to request, if it's in the cards, your inclination to take a step back and a pause, and maybe rethink this. Maybe you wish to take a revisit and come back before us. Maybe you decide to step back and redesign and you find that you don't need to come. That is that's your province at the moment, and I will make sure I extend that so that we do not pass this intersection without you knowing that, once we go past it, we're barreling headlong into what sounds like a motion that won't pass. So,
No,
with that, you
yes,
request,
we'd, to extend,
okay,
or
so,
actually, I'd reapply. Well,
well,
how do you handle that?
you'd want to continue.
Continue.
Yeah, basically,
When the
public hearing
is
is on. Right, so we're just continuing, the application. And if you were to be inclined to file new or modified designs or new proposal, or you discover that your new proposal that no longer needs zoning board relief, then we can simply take you off the agenda. You don't have to come back before us. But this gives you the option. So with that, when would we be able to?
Week 26, you have 40B plus 1 more.
Second.
So that's, and 9/9, you have 4 new items.
No. 8/6 or September 9th.
What was the first one?
August 26th.
Oh, 26.
Sorry, did I say 8/6? I meant August 26th, 8/26 or September 9th.
Or September 2nd.
It's 2 weeks. Can you do it in 2 weeks?
But, let me just, here,
One that has to come to final before we beat this.
26, okay, August 26.
Fills that. Fills that slot.
Maybe the same cost.
Did we have a preference? Apology.
Oh, yeah, August 26.
August 26th. Okay, that's a 40B night?
Yeah.
Okay, so that would close our 40B, that would close August 26th.
This 40B plus a.
That'd be 2.
Other current non-conformities and this.
At 40B is gonna be an hour and a half, easy.
Yeah, so, for the moment, we have 2, and we may choose not to add anything else. In fact, what's the inclination of the board? I would propose, I suggest we close that night now with this application.
How many are there now?
We have one, we have.
This will be the last. This will be the last.
It's not. Yeah, so,
Like 40B
and then,
and one other for Form
and it's this. So is the board inclined to, agree with me on this? We just close.
Yeah, we can.
That's it. Okay, so we close, this will be the last application, so now we have 40B plus 2, and 86 is off the menu. It's 86. Okay. So, thank you folks for your patience. We just have to do the ceremony, the formalities. So, we have a request from the applicant to continue the application to 8/26. Do we have a motion in a second? So moved. Thank you, Mr. Swanton, seconded by Mr. Delisle. Calling the roll on the motion to continue to 8/26. Mr. Swanton?
Yes.
Mr. Delisle? Yes. Mr. Bennett?
Yes.
Mr. Shannon?
Yes.
Mr. Ginton?
Yes.
Mr. Igerman?
Yep.
And I vote yes, that's 7 in the affirmative, ayes have it. We'll see you on the 26th. Thank you.
Great.
Thank you very much. Okay, that concludes our public hearings. So I will close public hearings to go to our business meetings. We have the approval of our minutes of 7/22/2025. Anyone have any comments on our minutes? Any changes?
No, I didn't.
We have a motion to approve our minutes.
Is it the minutes?
Yes, I had two. Gretchen, I tried. Luckily, you heard. I tried to just.
You tried to sneak it
I
on.
tried to force it on for, Mr. Shannon has a few comments.
Can you hear me, Gretchen?
I can.
Okay, item C, first paragraph, third line. I think it's supposed to say done on other properties. It says done on the properties. And then same thing, C, second paragraph, sixth line. I think it's supposed to say since last fall. Since fall. I think last just defines it. That's it. They're minor. Just
Very good. Motion to approve the minutes as modified and
So moved.
seconded. Voice. All those in favor? Those abstentions, ayes have, the motion carries. Thank you, Gretchen. Minutes are approved. The last thing is before us, we have our proposed section 2.5 remote participation, new rule. I've read through it. I don't know if anyone has any comments or proposed changes. This is a redaction of something that has already existed, I think,
I
with.
found a great.
Yeah.
This is, I don't know if this is a full class, but it actually says if you're gonna do remote. No other person is present within them. Within them.
Well,
Think about that. You don't have another person within you.
never is the case for me, so.
So I think it's not within, it should be there.
Who's a multiple.
It shows the claim.
Item E, procedures in remote participation, 1, 2, 3, 4,
Right.
one down, it's item B, 4. Third line says you can't have another person supposed to be with you or able to hear you talking, and it says there's no person present within you.
Well, we'll change that. Any other?
Yeah, I have a question on, did this kind of come from the city council? Is it?
No, I cribbed it from the state regulations.
Yeah.
So what I found was that although they keep changing the statute for COVID, they've never changed the regs. So this is the Attorney General's reg adapted.
Okay, so my concern, I was thinking maybe with city council, because their mics work pretty well here. I gotta tell you, I did this remotely last meeting, and right here under C1, it says members of the board who participate remotely and all people physically present at the meeting location must be clearly audible to each other. And I could not hear, I heard about half of Jared, none of Bud, none of Greg, a little bit of Steven. You.
That sounds like.
Well, that's why the AG has it in there.
Yeah.
We were,
I'm just saying, we could adopt this, but with that technology,
well, I
it
think
doesn't
the
work.
point is we should, Steve, for example, said by email today, we didn't really hear the.
Oh, yeah.
The
The night of July 8th.
I think we just have to be more honest when we can't hear.
Yeah, absolutely. But I think it's a guardrail. I think
It can work. It can work.
You have to pass a microphone along.
The issue, I'm not defending this whole thing.
That's what we used to do, right? We used to pass the
We
mic.
used to pass the mics. I
Yeah,
mean,
yeah.
if we were-
that would at least solve the projection.
Yeah,
Voice
because it's
projection.
just the people who are far from, for some reason yours works and the podium works.
Yeah.
Yeah, and members of the audience, they have to come to the podium. I know they don't like to. They
Yeah.
have to.
Yeah.
They're usually pretty, accommodating.
Yeah.
I haven't,
The night of July 8th, though, was very, I don't know if anybody's, you listened back to it. It was more than just not being able to hear people's voice. It seemed like it was a true technical difficulty.
Yeah.
It wasn't even working.
That stopped completely.
Yeah.
Yeah, there were a few minutes there where it shut off.
Yeah.
Yeah.
It was when you were talking, Jared, you were giving up like incredible wisdom. It's just like.
And then it shut itself off automatically.
the owl just did.
Yeah,
it.
in protest.
It's an editor.
It was, the owl was.
It's an AI editor.
That's AI, yeah.
What I want to propose is,
Ow.
is if we propose the changes we'd like, I think it's a fantastic architecture. I think the scaffolding of this, not surprisingly, because it comes from WJOP, and thank you, Jared, for pulling it in. It's very, very close to what I think, certainly I feel like I would love to adopt, but if it's in the cards, I'd love for us to suggest the modifications and then put it onto our agenda.
Are we shutting down remote participants basically other than ourselves? We're doing that because
We're doing it preemptively to streamline, I guess, the efficiency of our process and to make it more transparent.
it clearly works much better than people here. No shuts.
And we've never suffered sort of the the hijacking, if I could use that language that city council has dealt with. But it's, we're only one controversial and sort of galvanizing, application away from there being potential disruptions that could, they could seize control of our ability to control the room, right?
And clearly during COVID, it was brutal, like the Bryan hearings.
Yeah.
They made you have to remove them.
I think that it's time for me personally, I think we need to, it's a bold step, but it's really not that bold. And we're not, honestly, we're not breaking any glass here.
Are we the only ones doing it?
No, we are among the minority of those that are doing it.
It's still, has the city council done
Yeah, they don't do. City.
No, they take remote comments from the public.
But we can, they also, so we would be of the land use boards, we would be the first use boards. Does Concom do it? They still.
They're totally remote.
Right, yeah, so they haven't even come back. I think we would, it would be, it'd be kind of thought practice leaders in this, land use boards to just simply say, look, it's, it's only a city of 20,000 people, and our geography is such that you can probably get here by car, if not by bike or kayak, what have you. And it ain't that hard. So we need to just simply say it is now the our bylaws, and it is the expectation because it is the rule. And as long as we say it and we live it and breathe it, we've given people ample notes, it's gonna be the new normal, but I like it.
Are we the first to be doing it?
No, we're just, I think we're the first in the land use forms to be doing it. I don't know if licensing is still remote. They take public comment remotely. Conservation is fully remote. We're not even hybrid. Planning board is live with hybrid. And historic commission is live with hybrid.
Yeah, if I may.
Sure.
Defer to the board here, how you want to run your meetings. I think it's worth running a couple things for your consideration, just because we had some conversation in the office. We deal on a day-to-day basis. And we're also thinking about some of the procedural things that either you yourself might want, or Rob's suggestion, I created the idea. We're all the same.
Yeah.
But I think if we weren't just consideration that mind and jumping here presented people. And again, this is granted, there's a different experience we've had. Totally different changing things. We started running these Zoom meetings and so forth. So, and it granted there's issues with the equipment. We understand the IT division is now mobilizing people where we've been asking for years, which is the equipment. Right? Yeah. So just a couple of things to think about one way or the other. One is, I gave it to you to do a copy of just the notice language that we use on there.
Again, just keep in mind, this language was put together, sort of coming out of the COVID process, but it's basically trying to account for all the options, meaning it could be in person, could be fully remote, could be hybrid, but depending, we're not exactly sure, depending on the approach to the meeting. So the idea being folks could check 48 hours in advance, just verify one or the other. I mention that also because you might actually have yourself, other people, in other words, might have social norms in place. So is there an ability to shift to a remote meeting at that point, or we basically have to renotice and deal with black three for everybody what happened there? I do think that's worth considering in some way. There is the off chance, depending on the scenario, it's not frequent, not often, but there's a scenario in which the staff would be available for to host the meeting, so to speak. So you have to consider, maybe that option there. I did also want to suggest in A2, the part, and for not mentioning this earlier, but suggested in talking with others, we talked to the chair, talked about suggesting that you also allow your own legal counsel or consultant if need be, again, only if need be. But if that's the case, it also makes sense, I think, allow, say, staff of the city or say, the zoning administrator, if they can't be here in person, also participate, so you're not sort of shooting ourselves in the foot where we have to go to any expertise we might need in house here. So I think at least that had an exchange with legal counsel being reasonable. So just distinguishing applicants that are public. But maybe, I think there's a lot. But I just was a little bit concerned about keeping some flexibility on that in there. And then also, in addition to that question about, having flexibility to shift for, how you're dealing with it during adjusted weather conditions. You may not want to tie to a specific, either citywide, it could be just in one building that's not use. So again, trying to specifically that may be too rigid for a given situation in which the building itself, it may make sense to use one. Flip to remote. I just want to throw out.
No, can I just say, can I just, not to cut you off?
Yeah.
But what if we just simply added caveat language, by select or selectively by hybrid with notice of discretion. If we need to make a game day decision for reason, we get to do that. Still in due process, notice.
Well, yeah, it's just, again, it's just the end, agreed. It's just the end of the day that if the language here isn't adjusted to have any flexibility for that, then we're in violation of the rules trying to shift how they're doing it.
Let's just allow, we'll just build the back door, and we'll just build in the.
But also, it's just a rule. So by unanimous consent, you can
That's
always waive the rules.
That's
So
exactly right.
if there's a hurricane or something.
Yeah, again, I want to note here that you trying to get into a meeting to waive the rules is more difficult than having already adapted in the notice that we has. We might be functioning from a public notice. Or a meeting. I just want to, at the end of the day, I prefer not to have inconsistency. We've covered that ground. There's not any complaints about how we notice. And in addition, changing conditions we have in there, if depending on when the effective date is, let's say the rules change in effective date. Ideally, we don't have any inconsistency if we're saying new applications. We don't have inconsistency with applications that are continued from a given night, new ones that are given night. We have one set of applications where public comments take remotely because we don't want to do, new hearings. So I just want to throw out there just those considerations. I don't expect anything sort of inconsistent tonight, but I just want to flag it, out there that ideally we're rolling it, whatever we're doing.
And there's one comment, I like Rob's suggestion that you have something that like the chair can waive it. Special circumstances, such as a snowstorm. Just because I don't want every single person who sees our policy to say, oh, I think I'll call a chair and see if I can get this to go remote. That's right.
How was that dealt with before COVID? Because there were snowstorms before COVID. I remember there were meetings that, I think I remember there were meetings that were.
Generally speaking, it depends on the scenario. So maybe there's like a notice that might happen or something. We've tried on different instances where there's been a few instances in which we've been able to get either myself or board members who basically make it the person here physically to know that the thing's been, how it's set up. But we're just trying to avoid the type of issues that might happen. We have to see the sort of practical implications of some of these things. And we have too rigid or certain rules, you might actually not be able to do something you want the flexibility to do, or be able to do it mechanically because we're able to do it.
Well, the city council rules, the president of the city council has the ability to declare an emergency. But, so you have to trust whoever the president is going to play it straight.
Right. And we can even throw a force majeure, provision that simply, force majeure is simply an act of God, which basically says it can't just be just because. So it has to be tied to some force majeure, something beyond our control, hurricane,
Yeah.
wind, rain, volcano, snow.
Right.
Power outage, or,
Again, just suggesting more flexibility for those types of scenarios is all. At the end of the day, I think for the most part, it's what's going to bring the room. It's just, I just want to make sure you're leaving yourself. Weather or inclement, condition and.
Is the wording here a suggestion or what we're currently?
This is what we're currently sending out. Because we want people
It
to-
covers everything.
Sorry?
It covers everything.
Well,
Everything you just said.
the reason that
Right here.
I modified that language specifically sort of at the time of our, coming out of COVID, we kept it because we wanted to keep the option clear. And that's why I just pointed out is that we would want to also modify that to the extent there's anything changing here. We would want to confuse people one way or the other about, so we just want to be clear about how we post on the website, the information about the meeting as well as any legal reviews, that it's not inconsistent and do that. in conjunction.
I mean, check with the city solicitor. I don't think you have to advertise this, just because it's possible for some people to call in. I don't think it's true. We certainly didn't do that before COVID. We always said, before COVID.
Yeah.
This was the AG's rule.
Yeah.
And it was possible for people to call in if you were a member.
Yeah.
But we didn't say anything about it in our notices.
No,
We don't have to say anything about it anymore if this passes.
Yeah, right.
Yeah.
If that passes, we don't have to say it, but we can choose to be more inclusive, but I think we open up, but allow me to interject. I think what we're saying is, I think that we all, maybe we agree with you and the concerns. Planning department and the administrative complications that are presented with, with rigidity in the proposed new rule, with the absence of there being sort of a safety valve option upon discretion of the chair, based on, interruptions and force majeure related interruptions, which really covers, it's already a pre-existing sort of parent, force majeure is out there, right? It's acts of God, things that we can't control, or whatever else. It isn't just because, a friend of Rob's called me and said, I'd like this to be more convenient because I'm in St. Bart's and I'd like to make this whole thing remote so I don't look like I'm in St. Bart's. Like, that's not gonna fly, nor would I ever do. But I think that we should have this come back with, and we maybe have, if you could take pass at that.
Yeah, I'm more than happy to share with others or what happens, or just come back officially wherever.
Let's
do that.
Go ahead. We can have that come back.
Yeah.
We
And
don't,
again, it's just for the public notice, and I might have missed, and Jared, feel free to clarify if I missed something. With this, I think the piece that I was thinking that might be modified here is just clarification, for instance, that any butters or people who want to comment on something shouldn't expect to do that at home. They should come here physically.
Yeah,
I wouldn't want to mislead people.
That's got.
So whatever that result, that's one thing that might change here again.
Well, that's what I'm saying. I'm saying we need to get rid of this language.
And that's what I'm saying. Right, I just wanted you all to know how we're.
Yeah, no, I got you.
To Noah's point, is covering the scenario.
it just needs a little.
And then if this passes, once it passes in final form, we can decide its effective date and it'll be all new applications going forward.
Right.
We'll wash through anything that's being continued or bouncing through. Obviously anything that's started and is underway will continue, by the old rules. And then the longest impact will be presumably the legacy of 40B as long as that goes. But that will be behind the final vote on 40B, will also close the door on that previous rule. And honestly, it gives us, I think, very sound and credible legitimacy with respect to change. It's slow to be adopted, slow to be, rolled out. Right? We'll say, Jesus, I didn't know what to be surprised. Yeah. And I think we just sort of take the run at this so that we can see a sharper version next time. And if it's sharp enough, we'll vote. If not.
Yeah, I mean, you could just put it, right, so just put in a catch-all for an emergency declared by the chair.
Yeah.
It's fine.
Yeah.
Okay.
Yeah.
We want to make sure that when we do this, you hit the things that are important, because that's why meeting from something, pushing it, really.
Yeah.
And what I'm getting at is that we want to make sure attorneys and architects are here.
Absolutely.
Not online, they're here. And applicants for the most part, unless the chair says it's okay, are here, because you can't hear it. And it's hard to say, like, I signed it, I listened to it, but I couldn't hear everything. I couldn't hear this board.
Yeah.
And so that's important that we need them here. But I also hear Andy saying is we need the flexibility of the chair to say, you know, the show must go on, so we're gonna go hybrid. We might be that. I'm just saying in general, I get the flexibility, but at the end of the day, we want people here. And I
Kevin was very good with the idea, because I want to make sure a few things were like, they were very comfortable with the idea of making a distinction between the board and its staff and assistants versus the applicants and the general public, so they have no problem with that spectrum. I was just trying to deal with mechanical issues essentially.
understand, and
Issues in my.
I do want to make sure that if a homeowner physically can't get here for any reason, that they could watch this.
Yeah,
It doesn't have to be the best, if the city wants to make it, that's their investment.
yeah.
But I want to make it so if they're not able to come here, they can watch and see what's going on,
Right.
to the best of this. will do.
Yep.
But it can't be part of the meeting,
Right,
Yeah,
it can't be the meeting.
you're right, you're right, absolutely, it has to be spectator sport, not a
Yeah.
participation sport.
I just had one thought. You know, I may be overthinking this, but I just wonder if we want to add at the end of that. As determined by the chair in its sole discretion, so that. Yeah, I can envision theoretically possible. The brouhaha, some lawyer raises the issue about whether or not a lot of the property tax and et cetera. So
The same.
what?
That's great, that's great. And it would be, it aligns paragraph B with the spirit as well as the language of the rest of it, which ties it back to, we'll use the reasonable person standard, but the arbiter of that reasonableness has to be someone.
In my sole discretion.
Yeah, we can't over democratize the thing, else it's anarchy,
Right.
right?
Yeah, agreed.
So I
Yeah,
think
I mean-
that we just bite that bullet.
Yeah, just on what Greg's saying, and the reason I use the AG is just because it's established
Yeah.
Right.
and it's safe, doesn't mean they wrote it well.
Right.
When it's written, it's definitely in writing, so. Got that. Thank you for, Chair, thank you for taking the, thank you guys for
Yeah,
your
thank you.
participation in this too. So, unless there's anything else, do we have a motion to adjourn? So moved. All right, those in favor? All right, thank you very much.
Very quick, Ken.
All right.